Good afternoon. Welcome and thank you for joining us for the May session of our Community Associations Building Blocks webinar series. Today's session will cover the topic of community associations and debt collections. I'm Jen Vitters-Bassick, Marketing Coordinator of Events and Proposals at Ward & Smith, and I'll be your moderator this afternoon. If you have any issues with video or sound quality during the presentation, please reach out via the Zoom chat feature and I'll try to troubleshoot with you. Additionally, today's speaker is happy to take questions throughout the presentation. If you have a question at any time, please type it into the Q&A box. So we'll get started. Today's speaker is Thomas Wolfe. Thomas's practice experience encompasses a wide range of creditors' rights law and business transactions. His creditors' rights experience includes representation of financial institutions, lenders, community associations, and other creditors in collections and bankruptcy proceedings, as well as navigating commercial loan transactions and workouts. Thomas routinely represents creditors in commercial litigation, in addition to drafting complex loan and settlement documentation. A portion of Thomas's practice also focuses on representing planned community associations with a broad range of legal issues, including establishing and enforcing collection policies. I'll turn the mic over to Thomas and we can begin.
Thanks, Jen. Welcome, everybody. Thank you for being here today. That was a great introduction by Jen. My name is Thomas Wolfe. As she said, I am in our firm's creditors' rights practice section. As the name implies, my practice essentially encompasses anything related to debt collection, bankruptcy, foreclosure representation, and loan workouts. A lot of our work in this section is devoted to representing anybody that's essentially owed money, whether it be a financial institution, a lender, a bank, an individual, or in this case, community associations. As you know, it's certain to come up at certain points of time where you get one, two, or a few accounts where the homeowners either can't pay or are unwilling to pay or trying to withhold their assessment dues for other reasons. And so that's where our practice section meets with community associations. So here at Ward & Smith, I do primarily the lien enforcement and debt collection work for most of our community association clients. I do this stuff on a day-to-day basis. It's a good part of my practice at the moment. And so happy to be here and talk to you a little bit about today, and give you guys a little bit of an understanding of what it is we do and some of the pitfalls and things to watch out for on your end to help better protect the association and give us what we need to help make sure that the association's rights are preserved from start to finish. So as you'd expect, the analysis with debt collection begins always, as with everything else, with the governing documents of the association. There's a lot of statutes that apply to debt collection, and especially in this context for HOAs. But again, the restrictive covenants and bylaws of the association are going to ultimately take precedent in most cases. Generally, things we need to look out for there are generally boiler type issues that are resolved, but sometimes these documents can be drafted, they're a little bit old, outdated, and a bit quirky. And so we need to take a look in there and make sure that the interest can be provided for is correct and within the statutory limits. The same with late fees. There's always a provision in there that we like to see that the association is entitled to their legal fees above all. You know, it's one of our goals to try to recover not only what's owing to the association, but at the end, if you do get payment and our services are needed, to make sure that legal fees can be recouped in that effort, and that way the association is not left holding the costs on their own. So that's a very important provision we need to always make sure is in the declaration or in the bylaws that allow us to go after those. There's some statutes that allow us to do that on the back end regardless, but it certainly helps to have it in there. And so those are some of the things that are a primary concern before even getting started. Generally, as the slide here says, regular assessments, special assessments, and fines are all part of what we can go after. Fines kind of find themselves in their own particular bucket. And there's some restrictions that apply to getting fines and certain procedures that need to be followed to get those. And I can talk about those in a little more detail later on if we have time. But generally speaking, if there are fines and they're properly assessed to the account, they are all fair game to go after and place liens against accounts. We can go on to the next slide here. And the other end of that is the statutes that are in place that govern debt collection. And there's a lot of them. There's a different statute that applies depending on what type of community you have. 47F is the general statute that applies to most community associations. But 47C is a similar one that applies to condominiums. If you have an older community, sometimes you fall under the 47A window. And on top of that, there's numerous consumer debt collection laws that apply. Both North Carolina law and federal law have their own acts that apply and govern what can and more importantly, what cannot be done to try to collect debt. And so all of these different statutes kind of interplay and meet in the middle and govern how we go through this process. It's a very particular process. Very straightforward, but there's a lot of boxes that need to be checked and a lot of places that can trip up both the association and a law firm that's representing you in making sure that we follow those rules to a T. Things like providing proper notice, giving certain boilerplate terms in communication to provide notice of rights for homeowners are all things that need to be included in initial communications. Both by the association and the firm representing it. And so the risk there is that if you miss one of those things, even if it's something small or easily overlooked, it can open up the community to potential lawsuits and claims and certain sanctions and monetary awards for even small minor violations. On the larger end of the spectrum, if you do something that's prohibited, for instance, like one of the big ones that associations find themselves in trouble with is publishing delinquent accounts. It's you're not allowed to give that information from one homeowner to anybody that's not an owner of the property. And so sometimes you run into an association, not the ones that I represent, but sometimes people like to post on the clubhouse door a list of all the delinquent accounts as a way to try to coerce people to start paying their debts. Yet that's not allowed, and it can really end in a lot of penalties because they accumulate and they multiply per account and per violation. So those are some of the bigger end issues that you run into. But even something as simple as sending a debt collection letter or a demand letter to the wrong homeowner by accident could also land yourself in trouble if it's something that was done because you weren't following different internal procedures and not taking certain efforts to ensure that those accidents don't happen. I mean, the statutes understand that sometimes something goes out and goes the wrong way. And, you know, an honest mistake doesn't typically result in violations. But certainly if you're not taking the proper care and things like that start happening, it could lead to bigger troubles down the road. So definitely worth being on a lookout for. And so what does the process really look like when you have a delinquent homeowner? What are the steps that we need to take? Well, it's a very straightforward process. Like I said, the first step is sending out a demand letter, which does a couple of important things by checking off some of those boxes in those debt collection statutes. And then you can proceed with filing the claim of lien after about 15 days. Once you have a claim of lien in place, then you start having options on how to enforce that claim of lien. You can either file a lawsuit or foreclose. And both of those processes have certain pros and cons. One is generally better than the other, and I'll go through both in greater detail later in the presentation. But suffice to say, there's a couple of different things you could do with a lien, and sometimes the best thing to do is to do nothing at all. It really depends on a case-by-case basis, and you know what is the expectations and what we're trying to do with that lien. And so, step one is always going to be that demand letter. Next slide. So to claim a lien, right? What are we really talking about here? Why do you want a claim of lien? Well, the long and short answer is it's a good way to ensure you get paid. It's a good method to coerce payment, and it really preserves the association's rights to payment by stopping the homeowner from taking certain actions, either selling their property or refinancing it. Once that lien's in place, it stays on the record. It has to be dealt with as long as it's active and valid. So if he's trying to sell the property, the homeowner's trying to sell it, and any good closing attorney is going to run through the title search, and they're going to come across that lien, and they need to reach out to either our office or the association to find out what the balance is on that in order to deliver clear title to the new homeowner. Sometimes that's not done, but the lien remains with the property. So regardless, even if it is sold, as long as that lien's in place and it's valid, we could go after the new homeowner to recover under that lien. It doesn't go away. And that's the real teeth behind the debt collection purpose. So like it says here, the lien remains valid on the property until either it's paid in full, and that includes all assessments, interest, legal fees, and anything that's incurred on the account after it's paid. Or if a senior lien forecloses, so if there's already a mortgage on the property and our lien is filed behind that, a foreclosure can wipe out the lien. And that's one of the only ways that you don't ensure payment, but the debt itself does not go away. It does not prevent you from then going after the homeowner in state court and filing a lawsuit to recover the amount. You just lose the lien in that place. And then the third, claims of lien are only good for up to 3 years. That being said, as you approach the end of that 3 years, we can simply file another lien, and I hate the term, but we can renew it that way. Just by filing a new lien, it just stays in place, and you can do that as many times as you want. So how do we get the claim of lien in place, right? The first step, as I said, is the demand letter. And that's sometimes the most crucial, because if you don't check the right boxes, if you don't do what you're supposed to do under the statute, and find yourself in a lawsuit later on, you can open yourself up to defenses and potential counterclaims for missing a step. And that may result in you having to dismiss an action, to remove a lien you already had in place, and starting over from scratch, and then losing the benefit of a good amount of legal fees in the process. So it all starts with a good foundation, like anything else. Number one, the debt has to be 30 days past due before you can even consider pursuing it. That's one of the main rules. You can't go after it until at least 30 days past due. Again, the restrictive covenants might have a different date. Some say 45 days, some say 120 days. Again, that date is going to control, but at a bare minimum, 30 days is a must. That demand letter has to go out and provide certain information. Importantly, we got to give them 15 days to pay the account current before we can assess legal fees to their account. You also need to make sure we give them the name and number of somebody at the association they can discuss a payment schedule with, or a representative. If we're sending a letter on behalf of the association, we can certainly put our information in there and have that discussion. But you always have to make sure you give them the opportunity to discuss a payment schedule. Now, the association does not have to agree to any payment schedule, but they at least have to consider them on a case-by-case basis. Finally, you need to include a statement of how much is owing as of the date the letter is sent out. We got to make sure they know exactly what's owing on the account. That way there's no issues of hiding the ball. On top of that, there's also plenty of other boilerplate terms that are laid out in the federal and state collection acts that need to be put in there to allow them the ability to contest the debt if they want to ask for additional verification. And that certain language needs to be included in there as well. And one of the other big mistakes that are made that a lot of people overlook is where the notice has to be sent to. So just because you have one address on file in your at the association, it does have to go there, but there's also a requirement that you send it to any address listed with the county's tax office. And that's not information that the association usually has their hands on or even aware of, but certainly have to do the research to dig into other addresses that are listed in there where the tax bills are sent, and also send it to those addresses. So if you miss one of those, that's one of those small little issues that doesn't seem like a big deal. But if you get to a lawsuit later on, it could lead to a defense from a debtor saying, well, you didn't follow the statute and therefore your lien's not valid. And again, then you need to start over. So very cautious on that part. So now our lien's in place, our 15 days have gone by, no suitable response has been received, homeowner hasn't reached out to us, they haven't made any payments to the association. Now we're in place, we can file the lien. There's not much more that needs to be done. Again, this is the simplest part of the process. The hard work is making sure that you do the due diligence on the front end to get all the proper information and send out the notice. But saying you satisfy those notice requirements, they haven't responded. Now we just take a lien, fill out that same information, and file it with the court. The only difference is that we need to provide notice of the filing of that lien to those same addresses. But we also have to send it by regular mail and by certified mail. The statute requires that you exhaust every attempt to try to make sure that they're getting notice of this lien. Statute doesn't require that you actually serve them with it. So if we send it to all the addresses that are on file with the tax office and whatever address they gave the association, and they get returned or they're not noticed, or they're ignored, we don't need to prove they actually put their hands on those notices. We simply need to follow the statute and actually send it out in that manner. And it seems like we have a question here. What if they make a payment, but they do not pay the account in full? That's a great question. And again, it kind of depends. In most cases, when we send out the demand letter on behalf of the association, we generally ask that if the homeowner reaches out to discuss a partial payment or something like that, to direct it back to our office to avoid miscommunications between the attorney and the association and accepting payments and inadvertently entering into a payment plan or accepting a partial payment as satisfaction in full. That's the risk. But assuming what we're talking about is a homeowner goes online and makes a payment for a partial amount, that can be kept. There's no requirement that we need to accept that as payment in full or we need to return it. What we would tend to do in those cases is I would reach out to the homeowner or send a letter, say, hey, we've received your payment. We're applying it as a partial payment. If you meant for it to be anything other than that, let us know and we will either refund it or however you want to proceed. Give them that opportunity just to make sure that we're not depositing funds in a different way. The biggest issue is when they send in that physical check and then sneak in the memo line payment in full or full satisfaction and something like that gets deposited. Those are the risks that we're really talking about. And so if it was our client that was having that issue, we would make sure that all communications come through our office, or if those payments are received and there's any questions about whether or not to deposit a check, let us know so we can take a look at it and make sure that everything is okay. And at the very least, reach out to the homeowner and give them a courtesy to have it returned if they didn't intend it to be a partial payment on their account. And that would be the safest way to go about doing it. And another thing most associations do is once they turn over the account to their legal team, they shut off all payment methods online. And that helps lessen that risk, right, of someone going online to their normal payment portal and trying to make a payment on their account, thinking they're just going to bring the account current. And so when they realize that it's not accepting their payments, that'll prompt them to reach out to either myself or the association and get further information before they start making those payments. But yes, great question. Definitely can find yourself into trouble when someone tries to sneak that language into the memo line of a check. So again, yeah, filing a lien, just have to serve it out to those addresses. Once the lien's filed, again, it's good for up to 3 years. Only very limited situations are going to extinguish that. It's going to prompt, in the best case scenario, a refinancing or closing attorney to reach out to our office and try to discuss payment. We could take the hard line approach and say it's not going to be resolved. You pay everything, and that includes all of our assessments, interest, charges, and legal fees incurred up until the date of closing. And there's no reason the association has to accept anything less than that if they want to. Of course, that's not a hard and fast rule, and certainly negotiations can be had, and you can accept a partial payment that's going to assist with getting a property sold and get a new homeowner in place. In a lot of cases, you get a problem homeowner is not paying consistently, and sometimes you go through years and years of dealing with a homeowner. Sometimes the best result is getting the property sold and getting a good paying homeowner in place. And so those are different factors that come into play along the line that we want to consider. But it's always a discussion and always a negotiation about what are you willing to take before it goes away. And again, if nothing is moving and that's not happening, foreclosure is always an option, or filing a lawsuit to enforce it, which gives us a wide net of recovery against them. So let's talk about some of those enforcement options, right? Collections lawsuit tends to be what we recommend for clients in most cases. It gives a much wider net of recovery. You get different ways to collect on a debt besides just foreclosing. So when you think about a typical foreclosure, you think about the bank, they have their deed of trust or mortgage against the property, and the homeowner doesn't pay, and so they foreclose. And all that simply says is they get title to the property back, they can sell it, and then apply that debt to what's owing. And that's essentially the same thing you do with a foreclosure. But with a collections lawsuit, you can proceed with what's called a judicial foreclosure. So what you have is a lawsuit that's filed in state court, and you have multiple claims. So one would be for the full amount that's owing plus legal fees, and you can get a judgment that goes against the homeowner and however many there are, and is placed as a lien against all their real estate. You get a judicial foreclosure claim, which allows you to do the same thing you would in a non-judicial foreclosure action, which is take possession of the property, take title, sell it, and apply it to that debt. But the real difference there is having that money judgment that's in place. While your claim of lien is in place against the property itself, and protects you from anything being done to that property, a judicial entry goes against all of the property that's owned by that homeowner, and you can file it in any county in North Carolina and follow them or their assets to wherever they own it. So if you have a homeowner in your community and you're in, say, Wake County, and you get a judgment against them, you can then take that and file it against them in Wake County, and applies as a lien on all real property they own in that county. But if they own, say, a beach home in Wilmington, you can take that judgment, and for $10, you can file it with the New Hanover court, and now it acts as a lien on that property. And so what you can do is take that amount that's owed and stretch it across all of their assets. And so now, if they want to sell any of their properties, they have to deal with your judgment. And by opening up the net, it allows them, it's a lot harder for them to ignore. Again, looks like we have another question or two here. I'll read them out. So can you file lien if the homeowner is only receiving fines, but only paying enough to cover the monthly assessment? Yes, but it's a different process. So it depends on, number one, how those payments are being applied to accounts. In most cases, if your collections policy is in line with what we typically recommend, if partial payments are being made on an account, they should be applied first to legal fees, interest, late charges, fines, and then assessments. And this way, even if they're paying partial payments, they're not making the decision to, I want this payment to go to homeowners assessments, but I'm not going to pay my fine. Rather than giving them that direction, if you have a collections policy in place that dictates the manner of payments, you take the money and you apply it against what you want it to go after. So the difference is if you have an account that's only made up of fines. So say they have been paying down their homeowner association dues and there's no interest accruing, all that's on there is fines. That removes from the play deck foreclosure as an option. In other words, you can enforce a lien and you can place a lien against a property for just fines, but you cannot choose the non-judicial foreclosure option, which I'm going to talk about next. It limits you just to the collections lawsuit. And it also creates a messier situation. A lot of judges are very hesitant to foreclose on somebody's home simply for fines. It's not to say it can't be done, but you get a little bit more pushback by a judge who starts to feel a little bit more sympathetic for homeowners, and will try to dig into whether or not those fines were assessed reasonably, whether or not all the procedures have been done, and whether or not you're entitled to all your legal fees. Now, it's our position that regardless, as long as you follow the rule of the law, we can still do that. But the problem there is, court is what it is, and judges tend to be a little bit more sympathetic in those cases. So it's possible, just not the best way to do it. I would recommend that you get a collections policy in place that dictates how those payments are made, and avoid the issue altogether, and leave those homeowner association dues for last. And that would leave all of your options still open. Okay, so why filing suit is better. Another benefit, this perfect segue right here, recovering under the judgment is a little bit better. Not only do you get to place that judgment across the state against all the property that they own, but there's other methods you can take to recover from the judgment. It's a process called execution here in North Carolina. It's a very straightforward process that ends with us sending out a sheriff, and they will go speak with the homeowners. They will go look into their property, poke around, and see if they can find any other assets. And assets can come in a variety of fashion. In most cases, we're talking about cars, we're talking about boats, sometimes planes or helicopters, depending on how wealthy it is, the individual we're talking about. Execution can be applied to anything like that. I've even seen an execution against a business, and we've sent the sheriff in, and they've taken everything down to tables and chairs and things like that. And what they do is they'll take it, seize it, put it in storage, and then have a sheriff's sale. Most people know that sheriffs have sales for auctions for autos all the time, but that process applies across the board to any asset that we want them to go recover. It's a simple process if they find it and it's non-exempt, that we can pay for their storage fees up front. They'll take it, sell it at auction, and if it nets enough recovery to pay back those fees, anything that's left would come back to the association. It doesn't work in all cases because not everybody's got a boat or a plane laying around, but certainly there's a number of people that have several vehicles or family vehicles that you can go after. And it's not always about taking the item. Sometimes it's a matter of convincing a homeowner to reach out and try to discuss a payment schedule with us. One good war story I have is I had a guy who had all of the vehicles in his name, and he was also the owner of the property. But the vehicles were across the state because all of his children were driving them and they were in college. But it didn't matter because they're all titled in his name. And so once the sheriff started knocking on doors and threatening to take all of his kids' cars, which would affect their ability to go to college, he came up with the money to pay the judgment pretty quickly. So it's not always about going through the process from start to finish. Sometimes it's a matter of just getting their attention, and having the ability and to kind of twist an arm a little bit goes a long way in a lot of cases. And that's the real benefit of the judgment over the foreclosure. Sometimes you don't want to go through the process from start to finish. The association may not want to own real property that it then has to market and sell. Sometimes you want to use some of these other manners to go after them. Now, for executing the process, it really starts with notifying the debtor of their exemptions. In North Carolina, by statute, they're allowed to claim a certain amount of money in equity in their pieces of property, but they're very limited. and they do have to claim them affirmatively. So the first step, we provide notice and serve them with that. And they have just 20 days to respond and claim their statutory exemptions. And they're limited. They can take up to, say, $35,000 of equity in their home, or up to about $3,500 in equity on a vehicle. And that's great, but if they have a very expensive vehicle that they own outright and there's no other liens in place, that 3,500 can get eaten up. And if we can sell it for anything over that at auction, it's fair game and we can go after it. And the same goes for homes. The execution process applies to real property as well. So if they have a beachfront property at the ocean, and say there's no mortgage on it, we can put the judgment in place there. And then we can send the sheriff out, who will post notice on the door and post notice at the courthouse, and then hold his own auction and sell it to the high bidder. And that usually gets the homeowner's attention pretty quickly, once you're not just going after the property that they live in where the association has control, but start going after other properties. This happened actually very recently. Someone had a significant amount of farmland in South Carolina, and we were able to take a judgment, move it to South Carolina, and place the lien on all of their unencumbered farmland. And once we threatened to go after that and their other residents down there, again, it got them to talk to us about paying off their debt. The residence down there was worth over $800,000. Our lien was about $25,000. So certainly, if we went to sell it at auction, we could find somebody to pay more than $25,000 on a piece of land like that, and satisfy us. And they knew that. And so, again, that's all it takes sometimes to get paid. It's a matter of a coercion over other options. And that's something that's available with a judgment recovery and not necessarily the foreclosure option. But again, let me talk about the foreclosure option. What makes that a particularly useful tool in certain situations? Generally speaking, we tend to recommend foreclosure when the association is really over dealing with a homeowner. There's probably not a likelihood that you're going to get paid. In other words, they don't have other assets. This is the only asset in their name. There's probably not much to go after, even if you get a judgment. And you just want them out of the community. You want to bring somebody else in that's going to pay. In that case, a foreclosure might be a viable option. This is probably only good if the association is willing to see it through to the end, though. One of the biggest risks of this is that the statute limits the recovery of legal fees to $2,500 if a foreclosure goes uncontested. And so because of that limitation, there's sometimes going to be some out-of-pocket costs that the association is going to have to swallow. And so that's why it's only good if you want to see it through to the end, if the association is really serious about taking possession to the property and removing the homeowner. So that process, as it may imply, it's a non-judicial foreclosure. So this is a different procedure than a lawsuit. It's not filed and argued in front of a judge. This goes before the clerk. It's a very largely form-driven procedure. That being said, there's a lot of steps and it can be a very expensive process. First, you have to do some title work. Certainly don't want to go into the process not knowing whether liens are out there, whether there's an earlier mortgage. You don't want to buy something and then find out that it's already been secured, if that's not the case. And title work can be quite expensive. But if you already know that there's an earlier mortgage, that's not to say that you can't foreclose or don't want to foreclose. Sometimes you have the situation where a homeowner is paying their mortgage to their bank, but not paying the association. Well, if you file a foreclosure action, a couple of things can happen. Number one, the bank can step in and try to put a stop to it because they want to keep that homeowner in place to continue paying their mortgage, and they may choose to pay off the assessments and charge that back to their debtor. That is very rare. Banks typically won't mess with it. The most likely situation is the bank will let the process go through. And if that happens, the association then takes the property subject to that prior mortgage. In other words, you step into the shoes of that homeowner, and now the association is obligated to pay the prior mortgage in order to avoid a foreclosure. But again, that won't typically happen. The most likely is the bank will then foreclose on the lien after the association has foreclosed. And that's because if they get foreclosed on by the association, it's a default under the terms of the promissory note. And now the bank knows they're not going to get paid, so then they foreclose and take the property back from the association. So it's a messy process, really only results in getting that homeowner out, puts the bank in possession to then go sell the property to someone else. If there's not a bank in place, the association can then purchase it and own it themselves. And then it's on the association to market and sell the property themselves. It's typically not what most associations want. You're not in the business of selling property and making money on real estate. And so it's a very limited usefulness with the process. It can be expensive, but sometimes it's the only option that's out there that's going to really net the association what they want, which is a good paying homeowner. And with the other risks involved with not being able to recoup legal fees, you end up coming out of pocket just to make the process happen. And so it's really got to be the right type of situation to take advantage of foreclosure. Otherwise, we tend to see the judicial action as a much more superior way of getting paid if there's assets to go after. And so the final option is to just let the lien sit in place. And sometimes that's the best scenario. Sometimes it doesn't make financial sense for an association to go after a homeowner. Maybe they don't have any assets to go after. That's something that's called being judgment proof. If that homeowner doesn't have any vehicles that exceed their exemptions, there's no other property to go after but the subject property. Say the property has a mortgage that encumbers almost all of the equity in the property. There's not much to do except for close on the property. And as I said, it's probably not in the best interest of the association to do so unless they're willing to take on that risk to go through and see it to the end. And so what you can do is just let the lien sit. It's valid for up to 3 years. It's going to continue to accrue interest over that time. It's going to gather all sorts of late fees and other charges. Any legal fees that are incurred over that time continue to add to the lien. There's no requirement that we file new liens over that 3-year period to update the balance. It happens automatically and without having to take any further action. So once the lien's in place, it's done. It can sit and nothing else needs to be messed with up until you start getting closer to that 3-year deadline. And what you can do in a lot of cases is just let it sit, grow, and once you get a few months out from the deadline, decide then, is it large enough to justify taking action to file a lawsuit or foreclose, or do you want to let it sit and expire, or do you want to renew it? Another benefit of the judgment is that it's good for 10 years and can be renewed for another 10 years. So sometimes you let the lien sit and grow for 3 years and then decide at that time maybe a lawsuit makes sense, because now you can take that judgment, get it entered, and for up to 20 years, you can hang that debt over the homeowner's head. So you get a much longer time frame and you don't have to worry about refiling your lien every 3 years. It's a much bigger stretch of time. And in a lot of cases, there's not much the homeowner can do to get out from under it unless they want to actually pay it off. All right. So those are some of the options that you can do to enforce your liens. What are some other benefits? What are some other risks? That's what we're talking about with bankruptcy. Unfortunately, in a lot of cases, homeowners that aren't paying their assessments are in trouble elsewhere. They have a lot of other bills, they have a lot of other liabilities that are not getting paid at the same time, and eventually find themselves in bankruptcy. This isn't a course on bankruptcy rights, but I'll give a quick bit of a rundown of what that process looks like to give it some context. So when a homeowner files for bankruptcy, there's a number of different chapters they can file for. The most common are Chapter 7, which is a liquidation bankruptcy, and a Chapter 13, which is a reorganization. If it's a Chapter 7, that's one where the homeowner has no assets that are very valuable when they're underwater on all of their loans, and essentially a trustee gets appointed to come in, liquidate their assets, sell off their property, apply it to the debts, and then they walk away with a discharge at the end. A discharge essentially says anything that was owing that was provided for in this case is wiped out and you can no longer go after it. The difference in a Chapter 13 is that there is no trustee to liquidate the property. Instead, the trustee will oversee a plan that gets filed, a plan of reorganization, which allows the debtor to make payments every month to the trustee for a period of up to 5 years. And the trustee will disperse those payments out to the creditors in a fair and even fashion. And how this operates in the context of community associations, it has to do with the claim of lien. There's two types of claims in a Chapter 13 bankruptcy and Chapter 7, and that is secured claims and unsecured. Secured means your debt is secured by some asset, some piece of property, which is done by filing the claim of lien. This secures you to a much better treatment in that bankruptcy. Unsecured creditors, on the other hand, tend to get pennies on the dollar on what's owed. So if a homeowner owes the association dues, a claim of lien is not filed and they file that bankruptcy, you still have a right to payment in the bankruptcy, but given you don't have a lien in place, you do not get the benefit of a priority treatment. In other words, you're probably not going to get paid much, and at the end, when they receive their discharge in 5 years, it tends to wipe out those arrears that are owing before the petition was filed, before the bankruptcy action itself was filed. A secured claim is going to give you better access to those funds. You're going to get secured status, which means you get paid up to the value in the equity in the property. So if they do have a home that has significant equity in it, at least equity that is larger than what's owing to the association, you can expect payment in full. And if they don't, then that debt does not get discharged and you can still pursue them after the bankruptcy and your lien will stay in place. So that it's a good protection tool. And one of the main reasons why once an account gets delinquent for a certain amount of time, we recommend immediately filing a lien to preserve the association's rights. Not only does it secure your right to payment of legal fees, but in case there's a bankruptcy, you have a much better chance of repayment later on. And because they can file bankruptcy anytime and you don't know when that is, always best to be in that sort of position. Now, as for the association dues that are that come due after the bankruptcy, the law is a little bit open on that end. If you get a discharge, the rule says that they get a discharge to all assessments and arrears that are owing as of the date the petition was filed. Now, most debtors take the position that that discharge applies while the bankruptcy is filed as well. I don't think that a North Carolina court has yet ruled on that issue, and so it's open for interpretation. But the general rule right now in North Carolina is that you're obligated to pay your ongoing assessments while you're in bankruptcy, as well as those arrears. And anything not paid when the bankruptcy ends will have to get repaid as well, and you can then pursue the homeowner afterwards. So again, just crucial to get that claim of lien in place. Otherwise, there's a good chance that anything that's owing either before or during the bankruptcy itself could get wiped out. All right, and so some other things to keep in mind. And I know that listening to my presentation here, there's a lot of warnings and a lot of things that we can do to force debtors to pay, and taking their property and foreclosing on things and getting judgments, and that's all great, but I like to think of those items as backstops. Those are last ditch efforts. The goal is to get them to pay and to not get into the situation. If they are, you want to make everything as easy as possible to resolve without getting a law firm involved, without having to chase them through bankruptcy court or foreclosure. And so there's some things you can kind of put in place to help avoid these situations. And a lot of these things, many of you property managers are probably already doing for your communities, and but worth reviewing kind of the importance. Adopting a formal collections policy and sticking to it. I talked about this earlier for the benefit of the association of watching out for how to apply payments, but it also helps put the community members on notice of what the next steps are. It takes a lot of the decision out of the property managers and the board members' hands of saying, well, this account is delinquent for 90 days. Should we send a letter? Should we not? When do we send it to our legal team to take the next steps? It keeps everything fair and even across the board. You don't want to get in a situation where homeowners are complaining that they're being treated differently than their neighbors because maybe they have a lien placed on their house in 90 days, but their neighbor had one placed after 120 days. And so it helps keep things fair and even, but also if you stick to that policy, it's going to, people talk in the neighborhood and will, the word will get around that it's enforced and that these are hard deadlines and the association and its members are going to keep to it. Act early to collect account balances when they're small. And this is easier said than done because it's hard to chase after homeowners when you have small balances. It's easy to let those things grow quickly and get out of hand. And then it becomes a lot harder for the homeowners themselves to manage that balance, especially once it gets in the hands of the legal team and legal fees start assessing to it, that balance can grow pretty quickly. And so if it's small, reach out to the homeowner, try to work through it, get it paid and get it handled before it gets out of hand. Because that's when homeowners tend to ignore those notices and say, well, I can't pay this anyway. I'm just going to let it go. And then they spiral out of control. Offering a variety of payment options to your homeowners. And this is another critical one. You know, it's easy for me to pay homeowner association dues online on a payment portal, but that doesn't work for everybody. Not everybody uses a computer for those things. Some are prefer to use an old-fashioned check and send it in, or call it in with a credit card, or drop it off in person. So by allowing different ways to receive those payments, you lessen the likelihood that somebody's going to miss a payment. Again, payment plans, I talked about it earlier. You have to provide them the ability to enter into a payment plan if it's acceptable. You don't have to accept any of them, but certainly before you get to the point of sending out demand letters and sending it to a legal team to handle it from there, be willing to work with them on a consistent basis to put something in place to take care of it. If someone's only a few hundred or a few thousand behind and they have a way to pay it and it seems workable and it's something that doesn't have a lot of risk for the association, just be willing to see if they can stick with that payment plan. And if you're going to do that, I would suggest getting it in writing, at least have something in writing that they sign or an email they send that you can hold them to if ultimately payments start getting missed or they fall in default and you have to send it to an attorney to assist. That's certainly going to help go a long way in showing that you did everything you could to work through this, and ultimately there's been a default. And finally, I know a lot of communities do this, but suspend services and privileges under the governing documents. It's one thing to threaten putting a lien on place. It's one thing to threaten coming after somebody with a lawsuit. But once you start taking away the key to the pool, that's when people start really taking notice. Once you start taking away the gym membership and all the other amenities, and it's in the middle of summertime and they got friends come over, they want to take advantage of the pool and now they're locked out, those things will definitely get homeowners' attention to start bringing their account current. Again, same as with fines and suspension of privileges. There's plenty of red tape in the statutes about what notice needs to be provided and giving them the ability to be heard at a hearing before those things are done. But so long as you're following those steps, that can be a very critical way of trying to ensure payment early on before taking further action. And so that is the gist of Debt collection from start to finish. I know we kind of finished with a little extra time here. If there's any other questions, if anybody's got anything I missed or any particular issues that you tend to see pop up as a property manager, I'm happy to kind of answer questions you have on that.
Great. Thank you so much, Thomas. We'll give everyone a few moments in case they do have questions. For those of you in attendance, following today's webinar, I will send you an email with a list of articles related to the issues discussed today, a recording of the session, and a link to sign up for our community association's alerts. And I don't see any more questions popping up. So we so appreciate you taking the time to join us today. We hope you're able to take some of the information you learned and apply it to your own associations. Thank you again. And that concludes today's webinar.
Thank you.